Imagine a man walks into a polling station, confidently gives a name, casts his vote, and walks right out.
Sounds pretty normal so far.
Right, but the only problem, the man whose name he used has actually been dead for months.
Oh, wow. Yeah, that's a problem.
On its face, I mean, this sounds like clear-cut, undeniable voter fraud. But according to the absolute strictest reading of the law, he didn't actually do anything wrong.
I mean, it sounds totally absurd, but it's true. The specific law they were looking at made it an offense to impersonate someone who is, quote, entitled to vote.
Right. And dead people aren't entitled to vote.
Exactly. Since a corpse is very obviously no longer entitled to vote, impersonating one didn't technically break that specific rule. The words on the page, they just simply didn't catch the crime.
It is absolutely wild. And you listening right now, you sent us this massive stack of SQE revision notes, the solicitor's qualifying examination.
Yeah, a giant brick of paper.
It's literally a brick. And at first glance, a textbook about the legal system of England and Wales looks like a pure, agonizing memorization test. You know, dry, academic, the kind of thing you'd use to prop up a wobbly table.
Oh, for sure. But we've been digging through your material, and what we actually have here is, well, it's something far more profound.
Yeah.
This is essentially the developer's manual for society. It's the back-end source code running every single interaction we have.
Right, like buying a coffee, signing an employment contract, getting a parking ticket. We go about our days completely oblivious to this invisible machinery until we crash into a glitch.
And suddenly you really need to know how the system operates.
Exactly. So our mission for this deep dive is to bypass all that heavy legal jargon. We're going to extract the absolute best aha moments from your material.
Which there are a lot of, surprisingly.
So many. We're looking at the real power dynamics between judges and politicians, the secret codes lawyers use to bend words, and basically how the game is actually played. Okay, let's unpack this. We really need to start at the foundation, which is the common law system.
Right, this absolute bedrock.
Basically, judges in England and Wales are balancing three distinct pillars.
Yeah, so first, they're looking at Acts of Parliament, which are the primary statutes. Second, they're looking at regulations. And critically, the third one, they're looking at previous court decisions.
The precedent.
Yes, the precedent. But to truly understand how these pillars interact, you need a total mental shift regarding what a judge actually does all day.
Right, because, I mean, we are so conditioned by TV and movies to think of judges as these active investigators.
Oh, banging gavels and demanding the truth.
Exactly, dramatically interrogating a witness on the stand. But digging into this framework, it became so clear to me they aren't detectives at all. So judges here aren't like TV detectives investigating the crime. They're strictly like umpires in a tennis match.
Right. That is a perfect way to look at it. It's a very adversarial system, which means, well, it relies entirely on conflict.
Okay.
The lawyers are the players sweating out there on the court. They decide which evidence to serve. They choose which arguments to volley back and forth.
And the judge.
The judge just sits elevated in that high chair and calls the shots, in or out. They make sure the procedural rules are followed, but they emphatically do not jump down and grab a racket to play the game themselves.
But wait, if the judge is just the umpire calling the shots, who is actually writing the rule book?
Ah, well, this brings us to parliamentary sovereignty.
Which genuinely threw me for a loop, because Parliament makes the primary legislation the acts of Parliament. But what shocked me is the power dynamic here. Wait, so even the highest court in the land can't overrule Parliament?
They cannot, not at all.
I mean, are you telling me the Supreme Court cannot strike down or rewrite an act of Parliament?
It is completely counterintuitive if you're accustomed to systems where a Supreme Court can invalidate a law for being unconstitutional. In this specific legal framework, Parliament is supreme.
So theoretically, if Parliament passes a law tomorrow banning, I don't know, left-handed people from driving, the Supreme Court just has to shrug and enforce it.
In terms of pure legal mechanics, yes. If Parliament passes primary legislation, the courts must apply it. They just can't strike it down.
That is so wild.
It is. Now, that immense power applies to primary legislation, but, Parliament obviously doesn't have the time or the expertise to debate the exact font size of a giveaway sign.
Right, or like the chemical limits of food preservatives.
Exactly. So they grant power to government ministers to create secondary legislation, which are often called statutory instruments.
Okay, so it's like delegating the fine print.
Precisely. And it trickles down even further into tertiary legislation, which is made under the powers of that secondary legislation.
Got it.
But all of that delegated authority ultimately flows from one primary source, a Supreme Parliament.
But here is where the system gets incredibly quirky, I think. Alongside all this supreme written law, there are these unwritten rules called constitutional conventions.
Ah, yeah. The gentlemen's agreements of statecraft. Yeah.
Exactly. It blew my mind that so much of how the government actually functions relies on rules that aren't codified into law anywhere.
They're really just traditions.
Right. It's wild that a meticulously documented system leans so heavily on, well, this is just how we've always done things, so we better keep doing it.
They might be unwritten, but they carry massive political weight. I mean, if you break a convention, you might not go to prison, but you could trigger a constitutional crisis.
Or collapse the government.
Literally, yes. And speaking of specific powers that sit outside the normal legislative process, there's also the royal prerogative.
Oh, right. Tell us about that.
So, for instance, only the executive branch has the prerogative power to enter into bilateral treaties.
Meaning Parliament doesn't do it.
Right. Parliament doesn't sit around negotiating treaties with foreign nations. The executive just handles that directly.
Okay, so Parliament writes the primary rules. The executive negotiates treaties, and judges are just the referees applying the text.
That's the setup, yeah.
But language is messy. What happens when Parliament writes a confusing rule? How does the referee know what to call when the tennis ball hits right on that fuzzy edge of the line?
This brings us to the absolute art of the legal system statutory interpretation.
Deciphering the text.
Yeah. Decades after a law is written, a situation arises that no one in Parliament could have possibly predicted. There is this constant pulling tension between what is literally written on the page and what Parliament actually meant to achieve.
Which takes us right back to our guy voting for his dead brother.
Exactly.
That was a perfect example of the first interpretive method, the literal rule. The court applies the everyday dictionary meaning of the words, regardless of the outcome.
And as we saw, it can lead to completely absurd results, effectively letting someone commit voter fraud on a technicality.
Right, because the literal outcome was so frustrating, courts utilize a backup mechanism called the golden rule.
The golden rule, yeah.
I thought of this as the common sense emergency brake.
That's a really good way to look at it. You start with the literal meaning, but if applying it produces a blatantly absurd or repugnant result, the court can modify the meaning of the words.
Just enough to fix it.
Right, just enough to avoid the absurdity. It stops the law from looking foolish.
Then you have the Mischief rule, which requires a bit of historical detective work. The judge asks, what was the actual problem, the mischief, that Parliament was trying to fix when they originally passed this law?
Yeah, and if interpreting the words broadly helps cure that specific historical mischief, the court leans that way. What's fascinating here is how these older, more rigid rules have largely evolved into the modern standard.
The purposive approach.
Yes, the purposive approach.
This is stepping back and looking at the overall purpose of the law, right? Not just the specific words and not just the specific historical mischief, but the broader intent of the whole legislation.
Exactly. And to figure that out, judges can actually look at something called Hansard. Yeah, Hansard is the official verbatim record of everything said during parliamentary debates.
Oh, wow.
So rather than just guessing what a law meant, judges can literally read the transcripts of the politicians arguing and debating on the floor when the law was being passed.
That is super useful. They use it to grasp the true spirit of the legislation.
Completely.
Okay, so that's the broad philosophical approach to interpreting laws. But lawyers also have these secret Latin cheat codes to parse the actual grammar of a sentence. I loved this section of the notes.
With the Latin maxims?
Yes. There are 4 key rules of interpretation that sound incredibly intimidating, but they are essentially just logic puzzles. Let's walk through them. I'll picture the tricks, you explain the rules.
Lead the way.
First up, justum generis. The trick to remember this one is same kind. If a law lists specific things followed by general words, the general words only apply to things of the same kind as the specific list.
Right. Think about a residential lease. If the lease says you are forbidden from keeping dogs, cats, and other animals, the landlord is clearly trying to ban domestic pets.
Right.
The phrase, other animals, is trapped by the specific words before it. You couldn't use it to ban someone from keeping a pet goldfish, but it definitely wouldn't give you permission to keep a wild tiger in your living room.
I love that. The specific words basically cage the general word.
Yeah.
Okay, next is nascitur associus. The memory trick here is look at the company the word keeps.
Yeah, a vague word takes its specific meaning from the surrounding words in the sentence.
So if a law regulates bicycles, tricycles, and vehicles, the word vehicle in that context probably means non-motorized transport.
Exactly, not a massive dump truck.
Yeah.
It prevents lawyers from isolating a single word and just twisting it totally out of context.
Okay, third is expressio unius est exclusio alterius. It is a massive mouthful, but the concept is brilliantly simple. If Parliament makes a specific list and leaves something out, you must assume it was excluded on purpose.
If the statute explicitly imposes safety regulations on buses and trains, a lawyer can't stand up in court and argue it should also apply to commercial airplanes.
Because they aren't on the list.
Right. The logic is, if Parliament wanted airplanes regulated, they would have literally written airplanes on the list.
Makes total sense. And finally, in pari materia, similar laws should speak the same language.
Yes. If there's another statute dealing with the exact same subject matter, judges will interpret similar words consistently across both laws.
So the entire framework doesn't contradict itself.
It's all about finding consistency and logic in a massive overlapping web of rules. And to truly understand how these rules are applied, it really helps to visualize the physical anatomy of an act of Parliament itself.
Because it's not just a giant block of text.
No, it has a very specific structure. It usually starts with a preamble, which sets the stage and the intent.
Right, then you have the extent provision. This is crucial because it clearly states where the act applies geographically, maybe just England, or maybe England and Wales.
You also have the enabling provision. Laws don't just magically apply the second they leave the printer.
But the ink is still wet.
Right. The enabling provision tells you exactly when the rules legally come into force. And finally, you have the short title, which is simply how human beings refer to it in conversation.
Like the Offensive Weapons Act 2019, rather than quoting some massive formal title.
Exactly.
So now we know who makes the rules, and we know the interpretive logic puzzles used to decipher them. But where do people actually go to fight over them? Let's move from the rulebook to the physical arenas.
The battlegrounds. Let's start with civil disputes, which generally revolve around one thing: money.
Always money.
You've been wronged, and you want financial compensation. The county court divides these civil battles into very specific tracks based on the financial stakes involved.
And the logic here makes perfect sense. I used to wonder why you couldn't just drag someone to the highest court in the land over a stolen bicycle. The system forces you into tracks to prevent financial ruin. The first is the small claims track, handling disputes unto £10,000.
Yes, but there are specific exceptions to that.
Right. For road traffic accidents, the limit is capped at £5,000. And for personal injury claims, it's a strict £1,500 limit.
The entire point of the small claims track is accessibility. If you are fighting with the contractor over a £4,000 botched kitchen renovation, you do not want a system where you have to spend £25,000 on lawyers just to win your money back.
That'd be a nightmare.
The rules here are relaxed, so normal people can represent themselves. Above that, you step up to the fast track, handling claims up to £25,000.
Then the intermediate track for cases up to $100,000. And finally, the multi-track, which is the deep end of the pool. This is for anything over £100,000 or cases that are exceptionally complex, even if the financial value is technically lower.
But, if your case is over £100,000, it very often bypasses the county court entirely and starts in the high court.
The high court.
The high court is the elite arena, and it doesn't just hear everything together. It's split into 3 specialized divisions.
Okay, let's go through them. You have the King's Bench Division, handling complex civil claims, and something called the Administrative Court, which deals with judicial review.
And judicial review is a massive check on power. It's where citizens can actually challenge the lawfulness of decisions made by the government or public bodies.
Wow, okay.
Then you have the Chancery Division. They deal with the dense, paper-heavy financial and property matters, complex trusts, contested wills, land disputes, and corporate law.
Sounds exhausting. And the third is the Family Division, handling high-stakes family proceedings like international child abductions, complex adoptions, and massive divorces. So that's the civil side. What about criminal cases? Civil is divided by money, but the criminal system is purely an escalation of severity, right?
It's basically a 3-tier ladder. At the very bottom, you have summary-only offenses. These are your minor crimes, common assault, minor shoplifting, traffic offenses. They are always dealt with in the magistrate's court, which is usually run by lay people, not professional judges. The maximum sentence a magistrate can hand down for a single summary offense is 6 months.
6 months, got it. Then you have either-way offenses. As the name heavily implies, these can go either way. They can be tried in the magistrate's court where their sentencing power for a single either-way offense is capped at 1 year, or if the facts of the crime are more severe, the case gets bumped up.
Right, up to the Crown Court, where you actually face a judge and a jury.
And at the very top.
At the very top, you have indictable-only offenses. These are the most serious crimes society recognizes: murder, manslaughter, armed robbery. They bypass the magistrates entirely for trial and go straight to the Crown Court.
I have a practical question about accessing these courts.
Yeah.
Let's say I start a business, and I hire a brand new, newly qualified solicitor to be my general counsel.
Okay.
Can they just walk into any of these arenas, from the small claims court all the way up to a murder trial, and defend me?
No, they absolutely cannot. The system regulates who can speak where through something called rights of audience. A newly qualified solicitor automatically has the right to represent you in the county court and the magistrate's court.
The lower levels.
Right. But they cannot waltz into the Crown Court or the High Court to argue a complex trial. To do that, they have to undergo further advocacy training and acquire special higher rights of audience.
It's essentially a licensing system to ensure a rookie isn't handling a life-in-prison murder trial.
Exactly.
But it's also worth noting that you don't always have to step into these arenas. The courts are clogged, they are expensive, and they are incredibly stressful. You can bypass them entirely.
Oh, absolutely. Through alternative dispute resolution, or ADR.
The escape hatch from the litigation machine.
ADR offers 3 main pathways. First is mediation. This is where a neutral third party sits down with you and the opposing side. They don't force a decision on you, they just facilitate the conversation to help you reach your own agreement.
Then there's arbitration, which is a bit more formal. It feels kind of like a private court. You hire a neutral arbitrator, they listen to the evidence from both sides, and they make a binding decision.
And the most common, simplest form is negotiation. This is where the parties, usually communicating through their respective lawyers, simply hash it out behind closed doors and reach a settlement without any third party getting involved.
But let's say negotiation fails. You go to court, you endure the trial, and the human umpire makes a terrible call.
Yeah.
You lose. How do you get a second chance?
You have to climb the appeal ladder. The general rule is that appeals move upward through the court hierarchy. In the civil system, if you lose before a district judge, you appeal upward to a circuit judge.
Makes sense.
From a circuit judge, it goes to the High Court. From the High Court to the Court of Appeal, and finally, if it goes all the way, from the Court of Appeal to the Supreme Court.
The criminal ladder mirrors this upward climb too. From the magistrate's court, you appeal to the Crown Court. And what's interesting here is that a Crown Court appeal from the magistrates is a complete rehearing of the facts.
They basically start over.
Literally a do-over.
Yeah.
Or, if you are strictly appealing a complex point of law, you skip the Crown and go to the High Court. From the Crown Court, appeals flow to the Court of Appeal. And again, from the Court of Appeal up to the Supreme Court.
But, and this is a massive caveat, you can only escalate to the Supreme Court if your case raises a point of law of general public importance.
Oh, I see.
By the time you reach that top level, it isn't just about your personal dispute anymore. It's about clarifying the law for the entire nation.
Here's where it gets really interesting, though. You cannot just appeal because you're angry that you lost your money or your liberty. You actually need permission.
You do.
For a civil appeal, you have to prove to the court that you have a real prospect of success or some other compelling reason why they should hear it. And in criminal cases, the threshold is incredibly strict to prevent endless litigation. To successfully appeal a conviction, you have to convince them that conviction is unsafe.
And unsafe isn't just a feeling that it was unfair.
Right.
It is a very specific legal threshold, meaning something went fundamentally wrong with the trial process, the judge's instructions, or the evidence. If you are appealing your prison sentence, you have to argue the sentence was wrong in law, wrong in principle, or manifestly excessive.
And the most fascinating quirk of the criminal appeal system, the double jeopardy aspect. The prosecution cannot appeal a jury's not guilty verdict.
Yep.
If the jury says you are innocent, that is it. The game is over. The prosecution cannot demand a do-over just because they disagree with the jury.
If we connect all of this to the bigger picture, every single time one of these appeals happens, it does more than just decide the fate of those specific individuals. It actively builds the common law. This is the doctrine of stare decisis, which translates to let previous decisions stand.
This is the lifeblood of the system precedent. There's vertical precedent and horizontal precedent. Vertical precedent makes logical sense. Higher courts, bind lower courts.
So whatever the Supreme Court decides, every single judge beneath them is handcuffed by that decision. They have to follow it.
Horizontal precedent is where the nuances lie. This dictates whether a court has to follow its own previous decisions.
Generally, the Court of Appeal is bound by its own past rulings, though the criminal division allows itself a bit more flexibility because people's liberty is at stake and they don't want to compound a past mistake.
That's a good safety net.
The High Court is bound by the courts above it, but not by its own lower-level decisions.
But the Supreme Court, the absolute top of the ladder, is not strictly bound by its own earlier decisions. If they realize a precedent set 20 years ago is completely unworkable today, they have the power to change their mind.
They do.
But I do have a question about how this precedent actually forms. Let's say a judge is giving their ruling on a contract dispute, and halfway through they just go on a massive tangent. They start ranting about how modern technology is ruining society. Does that rant become binding law for lower courts?
That is a classic exam hypothetical, and the answer is absolutely no. This highlights the vital difference between ratio decidendi and obiter dicta.
We couldn't leave without a little more Latin.
Exactly. Ratio decidendi means the reason for the decision. It is the core essential legal reasoning that was absolutely necessary to resolve the specific facts of that case. That precise reasoning and nothing else is what creates the binding precedent.
So the rant about technology is the obiter dicta.
Yes. Obiter dicta translates roughly to things said by the way. It encompasses all the extra comments, the hypothetical scenarios the judge explored, or personal observations.
Okay, got it.
They might be highly persuasive, like a lawyer in a future case might quote them and say, look at how this brilliant judge viewed technology, but those comments are absolutely not binding on anyone.
And along those same lines, only the majority judgment creates binding precedent. If you have 5 judges on a panel and 3 vote one way, while 2 vehemently disagree, those dissenting views operate just like the obiter dicta.
Highly persuasive, but not binding.
Exactly. They are incredibly persuasive. Scholars will debate them for decades, but they aren't the law. So what does this all mean for you? You sent us these notes, and by walking through them, you now understand the hidden architecture of England and Wales.
The source code.
You know that Parliament is the supreme rulemaker, immune to being streamed down by courts. You know that judges act as umpires, interpreting messy language using literal definitions, historical context, and strict grammatical traps.
And Latin tricks.
So many Latin tricks. You know that disputes are funneled into very specific physical arenas based on the financial pain or criminal severity, and you know that the entire ecosystem is held together by a rigid ladder of appeals, where today's ruling literally becomes tomorrow's binding code.
It is a meticulously structured machine. Every civil track has a precise financial limit. Every court has its exact place in the hierarchy, and every single word of a statute is endlessly dissected.
It's amazing it works as well as it does.
It really is. But looking at the entirety of what we've discussed, this raises an important question, something for you to really chew on long after you close these study materials.
Oh, what's that?
Well, remember those constitutional conventions we touched on right at the beginning? The unwritten rules about how the government operates that aren't actually laws.
Like the gentleman's agreements?
Right. We've just spent all this time detailing how the entire legal system relies on exact wording, strict precedent, and judges acting as rigid umpires enforcing written boundaries. So what happens to the balance of power when a real crisis hits, and it tests those unwritten rules?
Oh, wow.
If a convention is shattered by a politician, there is no text for the umpire to interpret. The system relies entirely on people voluntarily agreeing to play the game fairly.
That is a brilliant point. The source code only works if everyone agrees to respect the language it's written in. Thank you for joining us on this deep dive into the legal system. Keep questioning the invisible structures around you, and we'll catch you on the next one.